This is the first of 2 videos assessing how true is the cliché that you should never ask a witness a question if you don't know the answer that they'll give. In this video, we'll look at examination in chief. We can immediately discount the civil law where the witness statements stand as the witness's evidence. Statements should be complete and address all the evidence, and so examination in chief is unnecessary. But the situation is very different in criminal law if you are prosecuting. Well, why is that any different? Well, there are 2 reasons. Firstly, it's about how prosecution witness statements are taken. And secondly, a prosecutor in a criminal case has a different ethical code to other advocates. And our exception puts these 2 factors together. So let's first be clear to distinguish how criminal and civil witness statements differ from each other. Civil law witness statements are taken by the lawyers, and they're taken after there's been a considerable communication between the parties who are obliged to attempt an out-of-court settlement. Because the lawyers write them, and because there's been time to define the issues that separate the parties, the statement should be focused, relevant, and complete, and so no examination in chief is even necessary. But in criminal cases, those conditions are very different, often opposite. The witness statements in criminal cases are usually taken by the police and taken as quickly as possible, before memories fade or become contaminated. They're therefore taken at a point before there's been any sensible engagement with the defence. Indeed, the identity of the defendant is often even unknown. So how can anyone expect the police officer taking the witness statement to know what precisely to address before there's been any engagement with the other side? Well, they can't. No trial lawyer should assume that a police officer taking a witness statement has asked every possible relevant question of a witness. So criminal statements are imperfect. What they might be lacking is exactly what the criminal lawyer has to figure out. This is part of what we call developing your case theory, and it's a component of almost all law school assessments. And remember, of course, because the statement isn't perfect, that's why we have examination in chief in a criminal trial. And that examination is not just an exercise in trying to recreate word for word what the police officer thought to ask the witness at the time of the incident. But many advocates then think, well, they're worried. What if I ask a question and I get an unexpected answer from the witness and it doesn't help the prosecution case? Well, I suggest that's not really a problem. And that's where the prosecutor's ethics kick in. A prosecutor is not just trying to win a case at all costs. That's not their ethics. All that a prosecutor must do at all costs is get to the truth and to be fair. And if that means finding out evidence that has not yet been found out, it's not ideal we've had to wait for the trial to acquire it, but if it's your responsibility and it's not known and the trial is the last place to find out the evidence, you find it out. So bear this always in mind. There isn't a downside to the truth when you prosecute. So for those reasons, yes, it is regularly true that prosecutors in criminal trials, when examining in chief, will ask witnesses questions when they're not absolutely sure how they're going to answer them.